The prosecution says, give me your alibi. The defense says, take this motion to dismiss in the Bryan Kohberger matter. The Department of Justice has filed a superseding indictment for Donald Trump. Vigilante or hero, Carlee Russell has been charged with only misdemeanors. Keegan Kline, yeah, that guy, he's been sentenced. Todd Chrisley complains about prison. And then finally, our dumb criminal of the day. Let's talk about it. Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell. And remember, you can listen to us on any of your favorite podcasting apps at any time. All right, let's go ahead and begin the docket. Let's open the record for July 28th of 2023. So the prosecution says that the no alibi notice that was provided by the defense is insufficient in the Bryan Kohberger matter. Now, the Latah County prosecuting attorney is asking the court for an order compelling the defense to comply in full with the Idaho Code, specifically Section 19-519 and the Idaho Criminal Rules 12.1, and provide the state with notice of any alibi that may be offered herein, including 1, the specific place or places at which the defendant claims to have been at the time of the burglary and the homicides in the case. 2nd, the names and addresses of all witnesses upon whom the defendant intends to rely to establish such alibi. Now, as you may recall, we discussed the defense notice to the notice of alibi requirement. Now, the defense argument was that they have not had time to establish exactly where Bryan Kohberger was at the time of the quadruple murder, but we'll bring it out through cross-examination and expert testimony, more than likely, to show that Bryan Kohberger was not there and that he could not have committed the crime. Now, the prosecution points out that the scheduled October 2, 2023 jury trial is barely more than just 2 months away. And if the defense intends to rely on alibi, they must be required to provide prompt notice to the state to fulfill their obligations under the statute and the response to the notice of alibi. Any further delays will substantially prejudice the state's rights. Now, they state or note that the United States Supreme Court observed in a case called Taylor v. Illinois the ease with which an alibi can be fabricated, and the state's interest in protecting itself against an 11th hour defense is both obvious and legitimate. So let me just be clear here. Alibis are not easily created. It may be hard to believe, but most people won't get on the witness stand and perjure themselves for someone that they know, saying that they were with them when they weren't. Also, you have to remember, attorneys can't put someone on the stand if they know they're going to get up there and perjure themselves. So there's another problem with that. So, like I said, the state wants an order from the court specifying where the defendant claims to have been at the time of the alleged offense and the addresses of who's going to be in support of that alibi. And they want it, well, not now, but with at least in 10 days of the court order. Now, let's talk about this for a moment. If you have a rock-solid alibi, and you can prove that, let's say, your client was not at the quadruple homicide, but he was across town maybe at an ATM machine, and you can prove that, you would want to promptly disclose that to the prosecution so they can go confirm it and check it out and end this nightmare for your client that has been arrested and been able to make a bond. Yes, that's right. You'd want to get that done. But look closely at what the statute says. The witnesses you intend to call to support the alibi. It doesn't say the defendant can't testify to his different location if he were to choose to testify. He doesn't have to identify himself. He has a Fifth Amendment right against self-incrimination. He does not need to make the decision as to whether he's going to testify in his own defense until basically all the evidence has been presented, certainly in the prosecution's case in chief and any witnesses that the defense might have. He does not, the defendant does not have to make that decision until that very end moment. So in theory, Bryan Kohberger can say where he was and call no one else to support it other than himself. And frankly, there's nothing the prosecution can do about that. Maybe he was out for a drive. Maybe it helps him think when he drives in the middle of the night. Just a coincidence that maybe he was out during the night when this quadruple homicide took place. But how does the prosecution prove that? Well, they're going to rely upon the DNA evidence. Remember, the most important element of any offense charged is that they have to prove identity. The prosecution must show it is the defendant, not someone that looks like the defendant, not someone using the defendant's car, or even using the defendant's identity, but it was in fact the defendant that committed the crime. Bottom line, coming from a defense attorney, the notice is the defense attorney is playing with the prosecution. It is a distraction for the prosecution. While they're working drafting motions to compel, guess what? They're not working on preparing for their case at trial. Remember this, 99.999% of all criminal cases never involve an alibi. Most cases come down to, I didn't do it. It's not you. It's not the defendant. You have the wrong guy. It is identity. We'll see if they can prove that the identity of the person that committed the quadruple homicides there in Moscow, Idaho, was Bryan Kohberger. Well, there is a hearing set for August 18th, obviously just a few short weeks away, and they're going to address the state's reconsideration of the order staying the time for speedy trial, the motions for a scheduling order, and also a review regarding the protective order. I'm sure that the motion, and I'm sure that the motion regarding alibi will be addressed and added on to that hearing as well. But here's where things get interesting. Now, this argument made by the defense on their motion to dismiss, well, it's interesting because, well, it kind of reads like a law review article, but I guess I should say in every law review article, there's always something, not much sometimes, that's interesting. But in this particular case, and I don't know if they pulled this from an article or if this has been something that's been argued and developed over the years in Idaho, but I'm going to hit some of the big highlights of this because it's kind of a lengthy motion. So we'll get to the good stuff, all right? And it's a motion to dismiss the indictment on grounds of error in grand jury instructions, or in the alternative, remand the case for a preliminary hearing. So the defense is saying that they want a court order either dismissing the indictment in this matter or to treat it as a presentment, kind of like a complaint and information, and then Bryan Kohberger would be entitled to a preliminary hearing before a magistrate. The reason why the defense says they're entitled to this relief is that the grand jury was misled as to the standard of proof recognized for an indictment. Now remember, what do you need to arrest somebody? Probable cause. Would a reasonable person believe that a crime was committed and that this person may have had something to do with it? Very low standard of proof. And that's what the standard the prosecution used. However, this is where you got to go back and read the statute, and it's a straight-faced argument. I don't think the judge is going to go along with it, but I may be wrong. But let's take a look at it. First, they cite the Idaho Constitution, and it says the standard of proof for a grand jury at beyond a reasonable doubt based upon the plain language of the statute. And they go into the fact that the legislative history of the statute at issue supports a beyond a reasonable doubt standard. Specifically, they say the Supreme Court in Idaho can't adjust the standard of proof as it is a substantive right. And the failure to properly instruct the grand jury as to the appropriate standard of proof is grounds for a dismissal of the indictment. And they argue that the grand jury was erroneously instructed with the standard required for a presentment. Thus, the court could treat the indictment as a presentment, basically like a complaint and information. What statute are they referring to? Well, it's Idaho Code Section 19-1107, and it states, the grand jury ought to find an indictment when all the evidence before them, taken together, if unexplained or uncontradicted, would, in their judgment, warrant a conviction by a trial jury. The statute was in existence at the time of the Idaho Constitution being adopted in 1887. And when construing the Idaho Constitution, the primary object is to determine the intent of the framers. That's right. Sound familiar? This is how you interpret legal documents. So, provisions of the Idaho Constitution must be construed in the light of the law prior to their adoption. Then they go into Idaho Constitution, Article 21, Section 2. All laws now in force in the territory of Idaho, which are not repugnant to this Constitution, shall remain in full force. So anything as it relates to the laws that were in existence to the territory of Idaho when they became a state are still the law. And they cite a case that says that's what the Idaho Supreme Court has held. And so they go on to say that in the text of Article 1, Section 8, the framers of the Idaho Constitution, general intent behind the section was to ensure that either a grand jury or magistrate stood between the prosecutor and the accused. And then they cite the proceeding and debates of the Constitutional Convention of Idaho in 1889. Then we go into a little statutory interpretation that says, as it relates to what the standard would warrant a conviction by trial by jury and what it means. The defense attorneys cite, the interpretation of a statute must begin with the literal words of the statute. Those words must be given the plain, usual, and ordinary meaning, and the statute must be construed as a whole. If the statute is not ambiguous, this court does not construe it, but simply follows the law as written. We have consistently held that where statutory language is unambiguous, legislative history and other extrinsic evidence should not be consulted for the purposes of altering the clearly expressed intent of the legislature. Where they go on to say that sets the standard of proof would warrant a conviction at trial. Well, that's the key word. The justification for a conviction at trial is and was proof beyond a reasonable doubt. So therefore, this argument is that if you cannot alter the language that is required in the Constitution, that the grand jury would have had to have found that there was evidence, proof beyond a reasonable doubt, and they were instructed that it's only a preponderance of the evidence, then it's not a good indictment, and therefore it should be released, or it should be quashed. Now they go through a very interesting history of the grand jury system as to why it's there. Basically, it's kind of the check on the government to protect everybody from the prosecutors, because as time has gone on, the old adage of you can indict a ham sandwich, because people just indict whatever is in front of them. But it was a different standard. It's very interesting. Maybe we'll go into it at a later time, but it's probably not something that most people want to talk about here. But the argument is thus that you have to go back and read the statute, the Constitution in Idaho going back to 1887, that says the standard for a grand jury is beyond a reasonable doubt. It would be. Therefore, the grand jury was misinformed. Make it a do-over. Once again, do I think the defense is going to win on this? I'm sure it's been made before. They're arguing it again. And the worst case scenario is the prosecution just has to put on a preliminary hearing. We'll see how that one turns out. Next, the Department of Justice files a superseding indictment. Yes, the people in Idaho could take note of this. For example, in the Lori Vallow trial, they amended the indictment with just a pen change. Yes, in the history of the grand jury, you have to go back. And that's why in the federal system, they go back. When you want to amend a date, add a defendant, change a charge, you must go back to the grand jury and present a new indictment, hence the superseding indictment. So the day after the Hunter Biden plea deal blew up in court, Donald Trump received a superseding indictment. The indictment against the ex-president accuses him of plotting to destroy surveillance video showing Mar-a-Lago employees moving boxes of unclassified documents. In addition, the complaint also alleges that the already charged Trump aide Walt Nada used a shush emoji in a text to a Mar-a-Lago employee when he mysteriously backed out of a trip with Trump, citing a family emergency. Now, while at the Florida resort, Nada met with property manager Carlos de Oliveira close to the bushes for some sort of discussion. The new indictment charges de Oliveira with conspiracy to obstruct justice, altering, destroying, or mutilating a document and making a false statement. The latest allegations allege that De Oliveira attempted to have another employee destroy the security footage, and when that proved unsuccessful, he is accused of draining the pool, soaking the recording equipment in the water, according to the feds. Prosecutors also charged De Oliveira with lying to the FBI during a voluntary interview, falsely claiming that he had no involvement in moving to the boxes of the classified documents at Mar-a-Lago, saying, quote, "I never saw nothing." De Oliveira told the agents that in the interview, and now he's indicted for it. Always remember, never forget, kids, don't lie. But the best thing is don't give a statement to the police. Then you can't be charged with lying. Now, of course, ex-President Trump has issued a statement noting that this is a continued, desperate, and failing attempt by the Biden crime family and their Department of Justice to harass President Trump and those around him. Well, they're coming for the good president. That's just the way it is. And whether he thinks it's political, he has to defend against it. And as we have said, the threat of imminent incarceration tends to break the bonds of loyalty. Clearly, the goal is to crack the aide and now the property owner to testify against the president, or former president, I should say, to be accurate. We'll see how things turn out there. And of course, there's also talk that there's an imminent indictment as it relates to the January 6th riots, where the now former president is supposed to be indicted. I guess we'll have that indictment watch as well. And yes, I think it's official. We are just about officially a third world country where everybody is getting indicted. And the bottom line is, don't we all have to know, just like old Richard Nixon used to say, the American people need to know if their president is a crook. Let's find out. But then again, they're politicians. They're all crooks on both sides. We don't want people there that are crooks. Why can't they just go do a little public service and go home the way it used to be? Now they stay until they're old and they freeze and they don't know what room they're in. But we digress. That's something for a much different day. Next on the docket, vigilante or hero. Yes, in this story, a man comes out of a mall to find his truck is missing. He somehow tracks the car down and finds two people in it, presumably the thief. Well, that man then holds the thief and another person at gunpoint. Well, the thief then pulled out a handgun and shot the vehicle's original owner, who then returned fire and struck both of the people that had allegedly stolen his car. Now, at some point, the person who stole the vehicle and who's now being held at gunpoint by the owner of the vehicle produced a weapon from his waistband and shot the owner. There you go. The male thief was pronounced dead at the scene, according to the San Antonio police. Now, the vehicle owner and the woman were transported to a local hospital where they were listed in stable and critical condition. Now, police say the owner of the vehicle had every right to look for his stolen property. The owner of the stolen vehicle certainly has the right to track down his stolen vehicle. Now, the police would prefer that they maybe talk to the police before they took matters in their own hands, but he did what he felt he needed to do, according to the police down there. Now, the dead thief's brother, of course, challenged the car owner's right to chase him down and kill him. The victim was my brother, and there are two sides to every story. Sure, Jose Garcia said. Now, whether my brother was wrong or right, he had a gun pointed at him. I guess he took it upon himself to defend himself. Garcia called the man who shot his brother a vigilante, adding that people should wait for the police. Now, isn't that rich? Isn't that rich? The people, or the family of the people that didn't follow the law, want the law to be followed the most when it affects them. Isn't that just rich? Yeah. Like I said, the brother goes on and said, this guy is a vigilante, not a hero. The vehicle is not worth taking someone's life. I don't care what kind of car it is. You don't take the law into your own hands. Now my mom, my family, we all have to suffer and just have to deal with it. Like I said, that's rich. Well, why couldn't this guy's brother, not steal the car? It's kind of my pet peeve. Hate people that take other people's things. It's not yours. You don't take it, right? Didn't your parents teach you that? You don't walk into the store and just take something. And if you did, they walked you right back into the store and you returned that pack of gum. Who taught these kids that it was okay to take other people's stuff? Let me know, vigilante or hero. We'll know what it means when you type in vigilante or hero. And I've said this before. I've represented lots of thieves and burglars over the years. What do they look for? Weak targets and homes without guns. Yes, I know it's anecdotal. It's not anything scientific, but the answer is always the same over the years from clients that I've talked to. Easy targets, no resistance, and somewhere where you're not going to get shot at. Think about that, ladies and gentlemen. I don't know. Think about it. That's all I have to say. So Carlee Russell, take a look at her new mugshot. She's smiling, keeping her chin up. That's right. She's the Alabama woman who told police she was kidnapped after she went missing for 2 days. Well, she was arrested this morning and charged with 2 misdemeanors for making false statements to police. Now, the police chief expressed great frustration that Russell was only charged with a misdemeanor and said that he is calling on state legislators to add an enhancement to the statute that when somebody falsely reports kidnapping or another violent crime, that it be punished more severely. Existing law only allows the charge to be filed as a misdemeanor, the chief said. And since Ms. Russell was charged with 1 count of false reporting to law enforcement authorities and 1 count of falsely reporting the incident, he added that the charge, they only carry a $1,000 bond, and it's only punishable by up to 1 year in jail and a $6,000 fine. Now, here's my thinking. My guess is in that room was probably a federal agent. And we know, based upon the last story about the property manager in the Trump indictment, if there was a federal agent in the room and she lied, charge it as a federal crime, lying to a federal police officer. They could charge it under the Assimilation Act since there probably wasn't interstate commerce involved. Hey, you got to get creative on these type of things. Misdemeanor for the time that she wasted, the fear, the panic she put everybody into. Certainly there must be some sort of attempting to influence a public official that's a felony down there. Next on the docket, perv alert. That's right. Keegan Kline is going to be kept away from society for the next 40 years. That's right. He is the Indiana man who spoke with one of the slain Delphi girls on the day that she and her friend were murdered, and now he's been sentenced to 40 years in prison after he pled guilty to 25 charges of obtaining images and possessing images, well, let's just say with children, and other counts of obstruction of justice. Now, Mr. Kline was arrested back in 2020 and ultimately charged with using at least 5 fake social media profiles to solicit sexually graphic images and videos from his victims. One of those profiles, Anthony Schatz, was used to contact 13-year-old Abby Williams and 14-year-old Libby German on the day before they were murdered in 2017. There was some suspicion that he knew who killed the girls, who spent the night together on February 12, 2017, and then went hiking to the abandoned Monon High Bridge the next day. Kline repeatedly denied knowing the identity of the killer, but last October, Richard Allen was arrested and charged with 2 counts of murder in that case. At about the same time, the judge was asked by the prosecutor to drop 5 counts against Mr. Kline. Coincidence? I don't know. Are there really coincidences in politics or the law? Not usually. Next on the docket, Todd Chrisley, right? You know of Chrisley Knows Best. You've probably come across his show at some point in time. Very annoying. Very annoying. But that's okay. Some people probably say that about me too. But I'm not in prison. And Mr. Chrisley believes he is being treated differently from the rest of his fellow inmates in federal prison, and he thinks his fame has something to do with it. Mr. Chrisley believes his celebrity status has resulted in some odd occurrences while locked up at the federal lockup in Pensacola, Florida. Now, he thinks that people are taking photos of him while he's sleeping. I guess that's because they saw Alex Murdaugh with his shirt off and all his little photos, and they figured, oh, we're going to get some of Chrisley. Anyway, he claims that he hasn't been receiving any mail, and he thinks it's getting destroyed, although he has no proof of that, and he doesn't understand why they would do that to him. Anyhow, Todd claims that his living conditions are terrible, claiming that the place is plagued by bad plumbing, possible mold, and no air conditioning in this brutal heat. And Mr. Chrisley submitted an application to get switched over to home detention confinement, which is never going to happen. Now, you have to remember, he's serving bank fraud and wire fraud charges for 12 years. He's not going to home detention. That just doesn't happen. Now, Chrisley plans moving forward and exploring all legal avenues to address his prison conditions. All right, practice pointer here. Let me give you some advice, Mr. Chrisley. Here's what any prison facility likes, and it is truly in your best interest, and you are sure to get everything you desire. First, you have your mom call, okay? Then you start having other family members call the prison saying that you're not being treated fairly, you're not getting the right food, or you're not getting your medication, whatever. And then when the families don't work, then you have your friends call. I'm telling you, this works every time. No, it doesn't. No, it doesn't. What people have to remember is they're in prison, okay? It's supposed to be uncomfortable. That's part of the harassment package. They want it to be so that you don't want to come back. And complaining about it doesn't usually get a whole lot. Now, there's tons of prison litigation that goes on. I didn't get my kosher meal. I didn't get this meal. I have this dietary restriction, all that stuff. But it's not going to help by suing them, saying you're not getting enough air conditioning at the federal prison. You have to remember, Mr. Chrisley, that federal prisons are about 90% nicer than any state facility you could probably be in. Poke that bear and see what happens. Who knows? Maybe you could get some sort of courtesy hold to somewhere in, I don't know, Louisiana in the summertime. Now, certainly I'm not your attorney, Mr. Chrisley, but I would tell you to suck it up. Please go to crimetalksearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to crimetalksearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to crimetalksearch.com, sign up today. You'll be happy you did. Next, finally, our dumb criminal of the day. On Sunday night, the Flagler County Sheriff's Dispatch received a report of a black Mercedes that had briefly traveled into the wrong lane and nearly caused a head-on collision. Well, needless to say, the deputies did what they were supposed to do, located the vehicle, and attempted to make the traffic stop. However, as you can see, the vehicle did not stop until it had reached the Advent Health Palm Coast area and parked near the emergency room. The driver, as you can see from the video, well, let's just say he demonstrated some indicia of intoxication. He was identified as Michael Alfonso. He's also a habitual drunk driver. Needless to say, he was uncooperative and appeared extremely intoxicated, so he was taken to the emergency room in a wheelchair from the traffic stop to be checked for any medical conditions that he may have, so the deputies don't get sued saying you didn't provide enough care. Well, let's just say Mr. Alfonso wasn't having a great day. He was arrested and charged with his fourth felony DUI, because he has 3 prior convictions, and 2 counts of failure to obey law enforcement. He's being held at the Sheriff Perry H. Hall Inmate Detention Facility on a $26,000 bond. Ladies and gentlemen, remember, if you want to be a drunk, you can be a drunk. Just do it at home. It's not illegal to drink. But when you get behind the wheel and you're drunk, then it becomes a crime. And it is dangerous. And in today's world, you almost deserve just to go to jail with a DUI if you do that. This isn't 50 years ago where people used to be able to drink in their car on the way home. It's the law. You got to follow it. And it's dangerous. Okay? Just had a case recently. A young woman goes to prison, drunk, goes down the wrong way on a road, injures 2 people very, very seriously. Prison. I'm telling you, it's avoidable. And in this particular case, yes, sir, you are a dumb criminal of the day. All right, I hope you all have a wonderful weekend. Please join us this weekend for the weekly recap, and we'll see you Monday. Have a great weekend, and we'll see you next time.